go to our regular legal advice slot. The third act, what to consider when planning ahead. Well, with a significant percentage of the population now over 55 years of age, what should they and their parents have in place legally to provide for senior years and their death, and why? So we'll be looking at things like wills, enduring power of attorney, advanced healthcare directives. So this may be of interest to you. I'm joined in studio this morning by Sharon Cahir of Cahir Company, who has a legal advice and solicitors firm here within County Clare. Good morning to you.
Good morning. How are you?
Very well, thank you, and thanks so much for coming in. I think this is something that is of huge interest to people because, you know, we never think it's going to happen, but all of a sudden people find themselves in a situation where they haven't the planning in place, and it's a whole lot of other issues they weren't ready for.
Yeah, it is, and it's interesting how, you know, it's the age demographic. People who would be interested are at a certain age to say, oh, maybe that's me. But what's arising, and particularly when I'm out speaking in rooms of older people, older now is from 55 up. We're, you know, and we have a lot going on. So we're thinking of our own families. You know, we have aging parents, and then we have parents at certain stages where you're saying maybe in their 60s, into their 70s, it's a time to get organised. Now, preferably earlier, but at a point, because the older we get, the more we want to comply with other people. We don't want to upset anybody. And it's really interesting that the lack of education and honest conversation sometimes is lacking to assist people, because sometimes there's many touch points people need to have to go, oh, I need to do something. And there's many things arising now under individual pillars of what's important to discuss. So when we talk about, you know, if we say 55 and upwards, then it's an awful lot more than just the end of life and when we're gone. I mean, the reality is none of us are getting out alive. So we think of that first and foremost, say, okay, let's put a plan in place for ourselves or mum or dad or Auntie Mary, and when they're gone, if they can't bring it with them, which they can't, what will we do? So that's really the easy part. But the reality is, and you're talking about housing this morning, we're talking about health. The reality is that all of these arenas touch into the older, as we age, I put myself in there, as we age into this third act or fourth quarter, whichever people would prefer to say, is that we are saying estate planning, easy enough to say, particularly as lawyers, people go, oh yeah, I know what you're on talking about. You're also about wills or how to prepare if we lose our cognitive capacity. But now we're talking about housing. We're talking about people in houses where there's no mortgages, and that's wonderful, but equity release, and how would that happen? We're talking about the housing situation, and not everybody owns their own house. Mm-hmm. So people, we had a call, you know, this week in relation to somebody living in a property for over 2 decades where they've now got notice. So we have you know, we have competing rights in terms of the landlord going, I don't like what's going on in the rental market, I really want to sell. Particularly we have older landlords now who are saying, well, this is my retirement, it's the height of the market. Pension. Absolutely. Yeah. And the prices are good. Mm-hmm. And to be fair, any auctioneer will say, look, they're really good prices. At a point, because we are in this inflated period, it will disappear at a point. It'll change a little for another period in the middle, and we'll be back into it again, as most of us have seen in our lifetime. So here's the point where people are looking to say, well, the landlords shouldn't sell, they should hold on to it. But if we're looking at an age cohort for 60 plus as their retirement and having a lump sum, it's very hard for older people to release money on their house, like their spry finance. It was called seniors money before. Not ideal, because the idea is you're deferring the repayment into the future, and the cost of the finance is so high, it's not so clear what would be left, if anything at all. So that comes with a red flag for people. So if they have a rental property, selling it is really the only thing that they're left with, and they mightn't have thought of doing it, but the new regulations coming in is certainly forcing everyone to look at it now, or maybe in 6 years' time, or lose the value in the middle if you sell it with an occupant.
Which in a way is a good thing to have a pressure point right now, that people do actually have to look at this quite quickly.
Yes, and I think over the last 12 months we've definitely seen the sale of properties where people have had a dilemma, particularly where they have very good tenants, and there's loads of people that have really good tenants and they feel bad about having to do it. But it's like any estate planning, any retirement planning, any third act or fourth quarter plan. What is it I need to do to provide for me? Because here's the truth, we are the wealthiest generation that have ever been. Now people say, oh, we've inflation, we all have no money, but the point is we have more money than anyone ever had, our forefathers, etc. And we're also living an awful lot longer. So if we're going to live into our 90s, then what is it that we begin planning for? So if the finance part is important. Equally so, protecting the finance. Where are you putting it? Financial abuse. As we get older, it can happen that we're much more susceptible to it. Who's minding us? And I certainly see it in the growing area of capacity that I'm involved in. As we lose our cognitive capacity, who would we appoint to be the decision makers for us in relation to our finance? And are there competing interests within a family where people would be concerned, well, if I'm in charge of the money, then somebody else is worried maybe there'll be none left at the end. So although we're providing for capacity and making an enduring power of attorney, it's a really serious decision for people to be aware who they're appointing and maybe what the family dynamic is in the appointment, because it can upset others. And I'm seeing that play out in the capacity courts, where initially it was straightforward, we're making an application for someone to be appointed a decision-making representative where there isn't an enduring power of attorney. What we are seeing now is people putting objecting notices, so there's clarity as to who would be appointed as the decision maker. And sometimes it's arising, the judge is seeing that an independent panel chosen, that's set up by the court and the decision support service, that putting somebody independent in is the best thing for the vulnerable person for fear of fallout within family. So there's an awful lot as we age,
extremities, isn't there?
that people maybe aren't aware of.
As you mentioned, Sharon, like, it's a very difficult conversation in some circumstances. Where does one start? Is the question, Mom, Dad, have you made a will? Is that somewhere to start?
Yeah, I mean, I think we all know we're going to leave. So the easiest thing to think of, has somebody got a will to deal with how things will arise as...
We don't want to know what's in it, we just want to know, have you made
That's
one?
it.
Yeah.
And the truth is, it's a very difficult conversation. I mean, that's the single biggest thing I have, either from people as the age to say, I don't know what to do, how will I do it, how will I take care of who's there? Because again, we have families where there's people with specific vulnerable needs, where people are trying to plan outwards in terms of perhaps a trust for a disabled child, who would be a guardian of that child if somebody is gone. So that's fairly specific, and it does push people to make some decisions. But it's interesting how it tends to be the decision that people put out, because there's so many things around it, they're worried about it, you know. So while Mum and Dad are minding a child or a family member that has vulnerabilities, then it's managing away into the future in a situation where you're thinking, well, if I'm not here, how will it work? Who would be the best person? What structure would we put the money in? That's something that much and all is, it's probably the most important will to put in place, is can be put on the long finger. So I think the first thing is to think, if I'm not here, what would arise? And if you work backwards from that, then we have a period of time, perhaps if we retire in our 60s, then what if we live until our 90s? What are the different steps of stairs that arise with that? And we talked about the housing, the finance piece. How are we going to manage our money as we're able to manage it and we move forward? Will we keep it in our sole name? Will we have it in a bank or a credit union? If we're in the credit union, could we have a nomination whereby it doesn't fall under my will and it goes directly out to the nominee? Is it a situation that I want to transfer some of my assets because I have a lot, and rather than wait till I'm 90 and I pass away, will I pass some of it now to some of the children? Sometimes people are thinking fair deal scheme.
Yeah, or inheritance tax as well, obviously.
Absolutely.
Yeah.
And that's why we call it estate planning. But what's really important, that everybody's unique circumstances are unique to their own family and the people within the family. So again, I like to think it's a chessboard. What pieces are moving where? Perhaps, even though everyone says I'd like it to be equal, it doesn't always fall that way. And it's really important for people to have a sounding board to understand, to say, oh, I get it. Okay, that can happen that way. Maybe there's somebody who needs to live in a house for life, and then where is it going after that? So there's many variants that can arise, but everybody's unique circumstances, you just need to think it out a little bit. And having a sounding board helps in that regard. Very often it's just an estate planning consultation I might have with somebody, so that a fresh pair of eyes to say, well, that's interesting, and how would that be? And in some ways it's a bit like coaching. You're saying to people, what have you got? Where is it? What's the final outcome you would like? And when people are making a will, then I always say you're making a will for their circumstances now. It's very hard to think out the 30 years, although people think they're making their final one. Really, everybody should have at least 2 or 3. And the cost relative to the value of it is quite low, unless it's very complex and there's tax. But most people don't fall into that. Most of us don't fall into that.
But the cost of not having a will
is huge. And if I sit as a lawyer and say that, so I'm glad you said it, if I sit and say it, people go, typical lawyers. But that is the point. And we see the probate courts are busier than ever before. We see people taking claims for the sake of having one, and then maybe there's settlements. And a lot of it can be, 100% of it won't be avoided. There'll always be situations. Many of the situations in my 30 years experience is not necessarily the value of the asset and people fighting over what it is. Very often it's emotional. It's sibling relationships. It's perhaps preference of a parent
Family
to
dynamics.
a child. Absolutely. And really, that's what, when parents are sitting in front of me, sometimes I'm saying, look, you're the matriarch and patriarch. No matter what age you are, when you say, don't take his bike and start pulling her hair, it doesn't matter if somebody's 10, 11, 12, or if they're 40, 50. You know, Mammy and Daddy still get to set the ground rules, or perhaps say out to say, I meet many people who I encourage to say, look, say it within the family. The greatest gift everybody can give you is just to get along, just to try and figure this out, and you've done your part to do it. There's many people listening this morning that say, oh my God, I'm not having that conversation. Sure, when I'm gone, they'll read the will and they'll see I already know there's some form of underlying issue. So I say to people, we all have a gut feeling. So particularly women, think about the gut feeling, what you're worried about, what the fallout is. That's what you're really beginning to plan for, or to think about when you're making a plan. And when you work backwards from that, you maybe think you could be in a hospital at end of life. You may not have your cognitive capacity. Would you like to appoint someone to be your voice to speak with your healthcare team? Because again, you hear people, I would come across it when it's in contentious situations and people are vying to be the, inverted commas, next of kin. In law, there isn't that word next of kin, although we use it very commonly, but you can now designate someone to under the Advanced Healthcare Directive and the new Assisted Decision Making Capacity Act, you can appoint someone to be in that role, because not everybody may want to take on your wish. If you say, well, I don't want to be resuscitated if I've had a long life and everything's fine, or I have a particular illness and it's just going to struggle at the end, just I'm at peace, let me go. And I think for end of life decisions, having been proximate to making one within our own family, it really does lift the guilt that one ordinarily may have, because you can see somebody being really ill and being able to go, she'd be okay with it, or actually he's okay, he mentioned it. So I would encourage people to consider that, and also the enduring power of attorney. I think what's important for me to mention this morning is that everybody really from 55 up, particularly now as it's a do-it-yourself document, younger cohort of people who technology doesn't put off, then make an enduring power of attorney. And it's low cost to change it if you're making it with the decision support service, where the challenge is arising a certain age demographic, perhaps later 50s into 60s, people who haven't IT experience or just don't like technology or computers. You'll have somebody that will assist you. But if you can make it. So you will appoint someone, it's a just in case document. If you lost your cognitive capacity, then you've appointed somebody to maybe take over your care and welfare, personal welfare decisions, and manage your finances. You'll have made your will and preference clear to them, and so therefore they'll carry that out. But what's really important this morning for me to say is people panic if they don't have an enduring power of attorney and if they can't do it. And the fact that solicitors have been blocked out of it in many ways for the moment, I said to people, do it if you can do it. If not, there's an application to court, where a seamless application that within 16 weeks, 18 weeks, a decision-making representative can be appointed from you, someone from your family. I give an example perhaps of Mammy and Daddy living at home, and Daddy might have dementia and Mammy's minding him and everything is great, but Mammy passes away and then none of the children can access the funds for Daddy's care, and so therefore how can they do that? Then you would make an application to the circuit court, a straightforward application. It's based on an affidavit when you're saying who you are and why it should be appointed to you to be a decision maker, and then in that case people should know that that is available to them to do if they haven't an enduring power of attorney, or if they can't manage the technology to do it. Then there is a way for that to be done, because the wards of court office has been disbanded now, and every ward in the state actually has been taken out of the situation.
But a lot of that could be avoided if the pieces are put in place beforehand. I want to ask you a quick question, and I don't know if you can answer it first. People are just wondering here, a message on the WhatsApp 086 1800 964. What is the general cost when it comes to making a will?
I would say you should be expecting to pay €250 plus VAT, say €350 all in. Generally, you say in our situation, somebody would ring, we send them a form to fill out. So you're doing a bit of homework first, thinking about what you have, and then make an appointment to go in and do one. Many can be made on that same day, but really it can straddle 2 meetings. So if you think about that, that's a fair bit of time in terms of what has to be put into it. But I would say it's well worth doing, and that would be for one person. For a couple, it would be different. And then if it's a trust will where there's vulnerable children, etc., that would be much more expensive, because there's a tax application to ensure that when the trust would come into being, that whatever would fall to that particular child wouldn't have a tax implication in the same way that it would have for children of a family under an ordinary will.
Finally, Sharon, long-term care, the Fair Deal scheme, it's something, I suppose, for a lot of people there's quite a bit of fear of the unknown surrounding it. What advice could you give people finally on that particular scheme?
Well, I would say, it's really when people bump up against it, so an aunt, an uncle, parents, and all of a sudden it comes very quickly at people to try and understand it. So I would say begin to become mindful at an earlier stage. People tend to hear the top line that if I use the Fair Deal scheme, my house has to be sold. That's not the case. It's only if somebody chooses to defer the payment of the nursing home into the future against an asset, and it tends to be the family home, that at the end, if there's a lump sum to be paid back to the nursing home, like it's an interest-free loan technically what you're doing, then a house or property may need to be sold. At a time of making a will, that would be an important conversation to have. Nobody's anticipating going into a nursing home, but if it happened, then for example, if you want to give your house to John, then the point would be that you want to be very specific. You say, well look, if there is any bill under the Nursing Home Support Scheme Act, then I want to pay it out of, for example, my credit union account, rather than it to be paid from the sale of a house if the charge was deferred into the house. So you can be very specific in making your will. A solicitor who understands all the components of ageing law, would mention that to you, so that again you're very clear as to what way do you want your assets to be distributed if, for example, it happened that you went into a nursing home. But I would say to people, it's the only show in town. Everybody wants to stay at home, but financially sometimes it's not possible, because the cost of care, sometimes the 24/7 care is not possible at home. Finding carers to go into homes is a huge, particularly in outlying regions in Clare, it's a huge problem. And also then illness, it may not be possible for someone to be provided for at home depending on the illness, therefore they may be in nursing homes. But one of the single biggest problems we have in Clare at the moment is we don't have enough beds, so people are having to be moved to the other counties around, which is very distressing on families, which is a bigger problem altogether. But I would say to people, it's there. The Nursing Home Support Scheme office is very client centric, so they'll take calls, they'll work through it with you. You can figure out what you would have to pay. They're very clear to tell you. So I would say to people, engage with it at the earliest stage. Don't be daunted. The form looks far bigger and unwieldy than it actually is, to be fair. And you may have to get a copy of your title from the solicitor's office, or figure out what money is coming into mum and dad particularly, or a spouse or a partner, and it's just filling boxes, so that ultimately it's looked at to see it's means tested. What do you own at the time you may be going into the nursing home? How will it be valued? And therefore what will you pay towards your care, and what's the shortfall that the state will pay towards it?
Okay, well, great advice as always, Sharon. Thank you so much.